Well, good morning again, and welcome to Landmark Chambers webinar on grid connection reforms in practice. And this is the third in a series of webinars we've done on planning, property, and power issues. Thank you very much indeed for joining the session today. It's nice to see so many of you here, and we hope that you'll find the session useful and informative. My name's Richard Turney. I'll be chairing the session today and speaking a little bit later. I'm joined by my colleagues Natasha Jackson and Odette Chalabi, who I will formally introduce in a moment. Can I just pick up a little bit of housekeeping, which many of you will be familiar with for these sessions? Microphones are automatically muted. You don't need to adjust your local settings. And if you do shout out at the screen, we won't hear you. We do welcome, though, questions throughout the session, but please put them in the Q&A section, which you can find somewhere on your screen. If you'd like to remain anonymous before you put your question in, make sure you tick the send anonymously box. We will try and answer questions at the end of the presentations and have a little discussion then, picking up the points that we can. The webinar is recorded. You'll receive a link to the presentation and the recording after the event concludes. If you drop off either deliberately or inadvertently, you can just rejoin the meeting by clicking on the original link once more. So I'll start by a brief introduction of my colleagues. First of all, we're going to hear from Natasha Jackson, who is a highly ranked public law specialist with experience across environment, planning and energy work, as well as mainstream judicial review. She has particular experience in respect of the intersection of human rights and property issues, Article 1 of the First Protocol, and she's a member of the Attorney General's Panel of Counsel. And Odette Chalabi is a planning, environmental and public law barrister. She has specialised and has particular expertise in energy infrastructure planning, both at planning inquiries and DCO examinations. She's currently instructed on a number of solar and battery storage schemes, including in the Green Belt, including those affecting heritage assets and those which use best and most versatile agricultural land. And she's also a contributor to the recently published Collinson and Hockman on energy law. So with those introductions, I'm going to hand over to Natasha, who's going to give the first presentation on the NESO decision-making and the programme going forward. Thank you, Natasha.
Thank you, Richard. So as Richard said, I'm going to be talking about the most recent updates in relation to the TMO4 Plus reforms. So I'm going to start by giving you a bit of an update on developments, largely focused on developments that have happened since kind of part one of this webinar that we did towards the back end of last year. So I'm going to assume a relatively high level of knowledge, but I will kind of canter through a bit of scene setting. If I start at quite a high level, I would really invite you to go back and look at the slides or the presentation from the previous webinar we did on this, because that should give a bit of the background. I'm then going to talk a bit about the milestones that are established under the queue management process. And then finally, I'm going to touch on some of the dispute resolution mechanisms and potential legal challenges that might arise out of matters that we will cover in points 1 and 2. So first, looking at development. So just a kind of quick recap. Firstly, obviously, we're talking about the TMO4 Plus overhaul that came in towards the back end of last year to replace the first come, first served model that had dictated the queue with a brand new first ready and needed two-gate model with the aim of prioritising plans that are ready to connect and that are able to demonstrate strategic alignment. So that's broadly alignment with the government's Clean Power 2030 action plan and various other strategic alignment criteria that are set from time to time, and enabling those projects to be the first ones that come through. And that scheme has been enacted through various reforms, principally to the connection and use of systems code, the systems operator transmission owner code, and various methodologies, which we are going to go into a bit more in this talk. Again, I'm not going to spend much time on this, but hopefully you're familiar with the two gates. We've got the gate 1, which is the kind of baseline readiness gate. We've got gate 2, which is the full readiness and strategic need gate. It's gate 2 that comes with firm offers, determines queue position, and is essentially a gate that in order to get an offer through, you need to be able to demonstrate a robust level of readiness with evidence. Gate 1 is kind of the fallback entry level gate, and we saw through the G2TWQ, the gate to whole queue process that took place towards the end of last year, that there was a kind of bespoke rationalization process whereby existing projects that had a place in the previous queue were kind of reassessed, and it was established whether they would meet the criteria for a gate 2 offer or if they would be essentially demoted to gate 1. I just will go back to the slide I skipped over, which was an overview on how that impacted projects. So as I said, for existing projects that had already been under the previous queue mechanism, there was an assessment process. If they were able to meet gate 2, there was a review of their existing contract. If not, went back a step. But obviously there are new applicants, new projects that are applying to the queue for the first time, and those application processes are batched. A couple of updates since last we spoke about this. Firstly, just it's helpful, I think, to signpost that NESO have published a connections reform post-notification customer handbook. There is a link to that on the slide, so when we send those out, you'll be able to follow it, which is essentially meant to be a sort of step-by-step guide for people who have received a decision under the gate to whole queue process, or a subsequent decision under the phased process. And I also just wanted to flag, many of you may be aware already, that another new addition to the process has been the introduction of the progression commitment fee, which was approved by Ofgem relatively recently. And this is essentially a security fee that projects that have a gate 2 offer may have to pay in to the system. And then if they are able to then meet their milestone offer, they get that money back. So it forms a form of security. And if in fact they do not go on to meet the milestone one, then they will drop out of the queue and will lose that security amount. Now that's not an automatic introduction. There's a threshold built into the system so that if essentially the queue performance is not looking very good, then that threshold will be triggered and the securities process will be instigated. But that is a new element, and more information can be found about that in the guidance. Something that we didn't spend much time talking about last time, but actually has become quite important to where we are now in terms of queue management, is the status of protected projects. Now, as I just explained, projects that were going to receive a gate 2 offer would do so if they can meet both the readiness criteria and the strategic alignment criteria. There were, under the gate to whole queue process, certain projects that were protected. Now, I've kind of simplified this on the slide. In reality, the structure of how this worked was that they had to meet the readiness criteria. All projects have to meet the readiness criteria. Within the strategic alignment criteria, there was a specific strategic alignment criteria which specified that you meet this criteria if you come under protection clause 1 or protection clause 2A. So I suppose technically, legally, you still have to meet the readiness and strategic alignment criteria. But built into the strategic alignment criteria are these two protections, which essentially were put in place in order to enable projects that were quite significantly advanced on the previous queue to retain their position. And there are a total of 340 protected projects as the gate to whole queue process commenced. Now, I'm going to leave that there for just 1 second because we will come back to this in a minute. But just kind of pausing to reflect on that 340 number, the weight of projects that required protecting under the methodologies is something that we're going to see as become very significant to how this is all playing out. And again, I'm not going to spend much time on this slide other than to point out that, sorry, just for context, this is a slide taken from NESO's, I think one of their most recent webinars. But what it shows essentially is the reasons why certain projects have not been given Gate 2 offers. They haven't been prioritised under that queue. And we can just see there from the top line, battery, 153 gigawatt. That's, clearly the most significant capacity contributor from this table. And we can see the reason for remaining projects not being prioritized is that protected projects took priority. So we can see that all of the projects that were prioritized under that category were ones that were protected. So again, just a bit of scene setting for where we end up here. So quite remarkably, very recently, so I think Friday last week, a series of events have played out, which I think probably some in this world will have seen coming. Last Friday, Ofgem published a response to a letter that it turns out had been sent by NESO but hadn't been published at the time, which is essentially a letter from the 2nd of October 2025. So, quite significantly before offers were handed out under the gate to whole queue process. And what we've learned from Ofgem's more recently published letter is that in October, right at the start of October, NESO and transmission owners wrote to Ofgem, essentially saying that they were not going to be able to comply with elements of the connections methodologies, and specifically the problem related to the requirement under those methodologies to issue Gate 2 offers to certain existing projects that qualified for protection. And again, I've picked out some highlighted bits this is all from Ofgem's letter where they summarised what they had received in October. But that explained that according to NESO and the TOs, if the connections methodologies were followed, NESO and TOs would be compelled to issue some Gate 2 offers with connection dates which were known to be unachievable, in some cases with dates in the past, as well as inaccurate points of connection in one case. And unsurprisingly, NESO and the TOs were concerned that this would raise compliance issues under other terms of their licenses, and the other instruments that were adapted in order to bring these reforms in. And that in cases where issued Gate 2 offers contained unachievable terms, they would shortly have to be followed with a further variation with revised connection dates and/or points of connection based on the best available information. So, I mean, just stepping back and pausing there for a second, this is quite a striking thing to have happened, that in October last year, as I said, before any offers were made, it was known to NESO and TOs that a lot of these offers that were going to be made could never be achieved. And I'm going to come towards the end of this talk about potential dispute resolution or legal challenges that can arise. But just pausing there, that is quite a stark thing to have happened in my view. And so we see here that NESO and the TOs write to Ofgem, essentially seeking relief from their obligations under their license. Obviously, Ofgem having approved the methodologies and being the license holder. NESO's letter, NESO and the TO's letter, explained that it's 210 of the protected projects that have been affected. So that's 62% of the projects. And yeah, it says that around 135 of these projects will have their connection dates delayed due to some form of network-driven reason. And 75 of these projects have their connection dates delayed due to developer-driven reasons. Now, obviously, an important question on many people's lips is why? Why has this happened? Well, according to the letter from Ofgem, Ofgem's view currently is that, currently as of last Friday, is that there appear to be a number of potential factors. Some of those are set out on the slide. But I think, a key question for many working in this field is this really a question of poor strategic planning? Is it that this was always a bad idea to start with? Is it more of a question of operational capacity, technical capacity? I guess lots of people will have views. I've seen and heard from people who have complaints about the effectiveness of the consultation process that took place, about concerns about prioritising, for example, speed over capacity. Anyway, I don't have the answers for you, but that is a very live question, I think. So what's going to happen about it? Well, I think the main point to take away is that Ofgem have decided that they're not going to grant relief for the obligations as a result of the delays. They have made clear that they do expect the delayed connection dates to be offered to be offered by NESO and TOs to still be as ambitious as possible. And I think I'm probably not alone in kind of wondering where this leaves us all. So Ofgem essentially took about 4 months, is that right? October, November, December, January. Yeah, 5 months to think about what's going to happen, during which time gate offers went out. Have now said that they're not going to grant relief, but they're also not necessarily said that they're not going to grant relief. And meanwhile, there's this kind of encouraging that the offers that are still going to be made need to be ambitious as possible, which again causes many questions as to whether offers are going to continue to come that are being set up for failure. So I think a big question in terms of where things stand at the moment. Obviously, the risk that's been built into the system, the lack of clarity, and potentially the knock-on effects that seem unlikely to be effects that will last only in this round of offers. It seems hard to fathom how this won't continue to be a problem going forwards in terms of kind of compounded delays, and that's all unlikely to give much investor confidence in the system. So there's quite a lot that I think is in this exchange to unpack, and unfortunately I don't have time to spend more time on it. I've included on the slides some of the more technical approaches that are being suggested in order to move forward and modify offers, but I think again the too long didn't read is that we can expect that modified offers are going to come out to those affected protected projects in the coming weeks, and we can also expect a timeline to be published in the coming weeks as to how this is all going to play out. So I'll pause there on that point for now. As I said, I'll try and touch on it again when I come back to talking about the legal remedies. I just wanted to canter through the queue management milestones, which have clarified a lot again since last we spoke. Again, I've tried to keep quite a lot of information on the slide so that if I don't manage to cover all of this, you still have the opportunity to come back to that if that's helpful for you. But to canter through, NESO have now clarified what the user progression milestones or queue management milestones are under the queue management process, and new guidance has been covered that sets those out. There's NESO guidance that's been published, but that also should be read along with the CUSC section 16, which has kind of more detail on what these milestones look like. And essentially, these are milestones that apply to all Gate 2 agreements. There are 8 of them that are prescribed. The kind of technical operation is that these milestones get added into the project's own construction agreement through the addition of Appendix Q. So Appendix Q is kind of a boilerplate type document, but it's modified for each project. And the timescales are broadly calculated by reference to that guidance that I mentioned. Some of them are a bit more bespoke to the project. Others of them are calculated by reference to kind of fixed dates that kind of subtract backwards from the contract completion date. And 2 important categories within the milestones. The first is conditional progression milestones. So if a project is not able to evidence that they've met those conditional milestones, NESO will terminate. And then we've got the construction progression milestones, which come a bit later. And if a project's not demonstrating that those are being met, then NESO may terminate. I've just extracted what they are from the guidance on the slides. I'm not going to spend much time, but you can just see there the first 3 are conditional, so must be met. 4 doesn't apply to transmission. This is guidance that only applies to transmission, but sorry, I've said jumping between slides that there is a separate guidance that does apply similar terms to distribution connections, and there's a link at that second bullet there. And then we've got 5 to 8, which are the construction progression milestones. Now, as I said, there's more information in the guidance. I'm not going to spend much time going through those, but I think probably helpful to recognise, and also because it feeds into the points I'll make about dispute resolution and legal challenge. There are quite strict evidence requirements that are built into the guidance to demonstrate compliance. So again, check the guidance for details, but at each step there are quite prescribed bits of evidence that the project has to provide to NESO in order to demonstrate that milestone has been met. NESO will perform evidence checks. So, for example, just milestone 1, if we go back, is that they've initiated statutory consents and planning permission. One of the evidence checks that NESO will perform will be to check the planning portal that milestone has been complied with. And then the big punchline to this is that quote there from the guidance at the bottom. If the evidence has not been provided, if it's been submitted by the due date and it's not accepted as sufficient, the termination process will be followed unless one of the exceptional issues which are specified is met. And again, it's the responsibility for the project owner to identify and apply for and provide evidence for the exceptions. The exceptions are specified, it's quite a closed list as CUSC 16.5, and there are details about the process. But I think the key point to take away here is apply quickly, apply as soon as there's awareness of a risk of delay. And again, there's quite a prescribed process for what needs to be specified and how that's going to play out. And then termination. So the circumstances in which a position may be terminated are if evidence is not provided at all. Well, probably if that's the case, that's going to not set you up for an excellent legal challenge, but it may be the case. If evidence is insufficient, now again, this is slightly more nuanced here. It may be that there's a dispute as to the sufficiency of evidence. From having a look at the evidential guidance, like, it is quite specific what needs to be provided. So I'm not hugely optimistic about there being much scope for debate in this area, but there certainly could be. And then the third is that an exception essentially has been applied for that NESO hasn't agreed. So I guess the outcome kind of leads you back in a circle to number 1 anyway. And again, some details about the process on how that will be followed are on the slide, but I'll move on now to dispute resolution. So in our first webinar, Richard ran through a lot of the ADR mechanisms that are available and that are baked into the system. I'll do a bit of a recap on that, and I spoke about the judicial review avenues. In our first webinar, that was focused principally on kind of the decisions themselves. So I think I was talking quite a lot about how you might be able to challenge the downgrading decisions, contents of a conditional offer, and so forth. Today, instead, I'm going to focus slightly differently on the impact of the connection delays. So that kind of off-gem NESO-TO exchange that I was talking about at the start of the slide, and touch a little bit on milestone decisions. I mean, I think really my focus will be on the first point. In terms of milestone decisions, on the previous slide, I just identified, there may be a dispute as to whether evidence has been met. And that is something that could play out. But I think this connections delay point is quite an interesting one. And as I'll come on to, quite an interesting one under human rights law as well. So just to very quickly recap, there's more detail on the slide, but in essence, there is a baked in ADR scheme. Worth flagging that there is new off-gem disputes guidance that has been published. I think when we last spoke, that was still in draft. The short point is that off-gem are keen to be as hands-off as possible, I think, is a fair way of putting it, in terms of having to resolve any disputes in relation to grid connection and grid reform. So their guidance essentially specifies that you must go through all of the NESO's own dispute resolution steps before troubling off-gem. Though interestingly, there is a provision within the guidance that it's only in exceptional cases, such as those where NESO or the DNO has breached its regulatory obligations or has failed to resolve an error, where you might be able to come to off-gem. So maybe we actually are moving into that territory if that is indeed the direction of travel. But I think the key question that will be in lots of potential litigators slash complainers' mind will be how long this will all take. Obviously, if you're a project being affected by the delays in the connection dates, and an offer that you thought was going to, e.g., allow you to connect at the end of next year is actually going to be pushed back considerably. Using the required ADR mechanism, which essentially makes you go through all stages of the NESO process before potentially then going to Ofgem, and then potentially even judicially reviewing Ofgem, which we talked about last time, is not a rapid process. And it's very much a commercial consideration that I'm sure will be in minds if this is a problem, which kind of leads us to judicial review and the prospect of an Article 1, Protocol 1 challenge. I put on the slide what A1P1 is, but essentially it's the protection, apologies, protection of the rights of property. And I just wanted to flag this quite briefly, again, partly because we don't have much time to go into it, but there is some very interesting case law on the extent to which a contractual right is a possession that is protected by Article 1, Protocol 1. The Breyer Group case, which I've popped on the slide there, is a very interesting and quite on point case, which was essentially a case about whether a legitimate expectation, but also contractual possession, had arisen in circumstances where government brought forward the date by which a new, I think, solar photovoltaic installation project would be installed, with reference to the applicable tariff schemes. And the upshot was that the project ended up abandoning their installations at significant financial loss and brought a claim for damages under Article 1, Protocol 1. So the court's findings in that case are, I think, quite comparable here. Obviously, everything will always depend on the nuances, and I could talk about how legitimate expectation then continues to play out under Article 1, Protocol 1 for a while, but I will spare you that for now. I think just bear in mind that there are potential A1P1 slash judicial review causes of redress, and that's generally a system that could be operated a lot faster than the dispute resolution mechanisms. Just in terms of kind of timeframes on that kind of thing, for a judicial review, you do need to bring proceedings in 3 months. But as I understand it, and I'm sure someone can correct me if I'm wrong, there haven't actually yet been any modification agreements sent out. So again, every case is context specific, but it would seem that the trigger point from which those 3 months would start running will be the point at which NESO actually does kind of formally acknowledge that the timeframes are going to be changing. So if you are likely to be in that position, or your client's likely to be in that position, you've actually got a bit of a head start to potentially start preparing and thinking about whether this is a route that you wanted to go down. Anyway, I will leave you there and pass you over to Richard. Thank you.
Thanks very much, Natasha. So I'm going to move on from the grid connections process to start to look at how that feeds into the planning system, the town and country planning system, and the impact of grid connections or absence of grid connections on planning applications. Make my slides move. Here we go. So I think at the outset, it's useful just to reflect on what is said in the various relevant policies about the location of renewable energy generation and so on. And the starting point in England is the framework, paragraph 165, which says that it's for local plans to provide a positive strategy for energy sources. And that includes identifying suitable areas for renewable and low carbon energy sources and supporting infrastructure where this would help secure their development. But those of us who work in the system will know that when you then look to local plan content, it is rare in England to see really clear locational criteria for renewable energy infrastructure sometimes there are mentions of it in the context of restrictive policies or in the context of applying development control rules to that sort of infrastructure. But to see identification of areas, site allocations, or particular areas for renewable energy growth is, I would suggest, vanishingly rare. In Wales, there's a more deliberate process, which has been in place for some time, but more recently reflected in Future Wales, Policy 17, and the pre-assessed areas for wind energy. There, the Welsh government has identified areas where, in principle, the landscape impacts of new wind turbines will be acceptable. That creates a presumption in favour of large-scale wind development in those areas. And there's also a restrictive policy which identifies that large-scale wind and solar will not be permitted in the national parks and AONBs, straight national landscapes. And Policy 18 then reflects the presumption in favour in Policy 17, which is that effectively within the pre-assessed areas, there's no further test of unacceptable adverse impacts on the surrounding landscape. Now, the practical application of those policies has proved more difficult, and there have been a number of decisions where schemes are partly within or wholly within pre-assessed areas, but nonetheless have faced substantial resistance and, in some cases, refusal. Turning then to the national policy statements for development consent order applications, the key point that I take from the energy suite, and we'll deal more with the policies in due course, but the key point is that the critical national priority designation of renewable energy projects means that in most cases that will outweigh other harms. So effectively, there is such a strong policy presumption in favour of the scheme that those policies which might otherwise drive the location of renewable energy development are likely to be outweighed by the benefits. And I think it's striking that EM1 in particular goes on to recognise that there are a whole range of things that might influence the delivery of particular types of energy infrastructure, in terms of market factors and so on. And effectively, the message when you read that policy as a whole is that EN1 is not one of those things. EN1 is not supposed to be restrictive as to the location of new development. In response to the Energy Security and Net Zero Select Committee report in the summer of last year, which I'm going to come on to in a moment, the government made this quite blunt and striking statement, which is that it does not intend for the planning system to decide where infrastructure, as energy infrastructure, should be built. Now, just taking a step back, one might have thought that's exactly what the planning system should be doing, deciding where things should be built. But in this way in which EN1 has been set up in particular, the government is effectively saying, no, there will be other factors which determine the location of projects, and general matters of planning considerations, the sort of mainstream planning policies in respect of landscape or heritage or even flood risk are not going to be drivers or principal drivers as to where renewable energy projects are located. I think we get a sense of this also from the Connections Reform Annex to Clean Power 2030, which is an interesting document and sort of looks forward to grid reform, but also sort of bakes that into how the government sees the grid connections process as taking or providing the route map to delivery of clean power. And there's recognition that effectively what is required is a system of breaking down geographically the capacity for connecting new renewable energy projects and providing a system where the grid connections process can start to locate and provide guidance to decision makers as to where renewable energy projects should be located. Noting that planning has a role to play, still need to secure planning consent, but it is not suggesting that it's the planning system which is going to identify where these projects are located. And we then come to the Strategic Spatial Energy Plan. And this is NESO's plan, obviously. They have been charged by Ofgem with delivering this. There's a huge amount of information about it. Consultations on methodologies have been completed. And that energy planning work is now firmly underway, with publication still promised, I think, by the end of this year. Now, what is said in the methodology for the Strategic Spatial Energy Plan about land use factors is worth reflecting on. So the SSEP will work on the zonal basis, which we've already seen identified, which will then go on to identify potentially suitable geographic areas for each of the potential technologies. And there'll be an assessment of various matters which might affect that, including what they call known constraints and assumptions. And interestingly, there's a reference to consideration of factors such as urban development, agricultural land, fisheries, and protected areas, identifying where those impose constraints. Now, of course, the slight confusion here, or potential confusion here, is that if the planning system, a town and country planning system, is not feeding back and saying this is a suitable location and this is an unsuitable location for the type and form of development proposed, then it's quite difficult to see how the strategic energy planning work can incorporate those factors. A good example might be agricultural land. At the moment, there isn't a policy of restraint on best and most versatile agricultural land. We can see that in recent decisions. Is it the case that that policy is going to emerge through the existence of such agricultural land informing strategic energy planning? And then the sort of caveat, which is that the zonal locations will not take precedence over other land uses, and they will not undermine the existing planning frameworks, which will be considered but won't be determinative of the strategic energy planning work. But equally, the strategic spatial energy plan will not dominate those existing planning frameworks. When you get to regional energy planning, this is again interesting in the language that's used, because whilst planning policies are said to be inputs into the RESP process, and whilst the RESP process is not changing what is said to be the accountabilities of local government or any other actor with responsibility for spatial planning, and there's no obligation to adhere to it, the purpose of the policy obviously is to start to identify how and where particular projects will be located within the identified regions. So Ofgem has set up this process of regional energy strategic planning, whilst accepting that in essence it is neutral in terms of its input into the planning system. These problems, or potential problems, were considered, as I mentioned briefly earlier, by the Energy Security and Net Zero Committee last summer. And it's an interesting report to read, and the government's response is interesting to read too. Effectively, on this issue, there are three key recommendations. They're spread throughout the document, but the three key things that I extract to this. Firstly, the planning system shouldn't be blind to strategic energy planning. Secondly, there needs to be coordination between the application processes for development consent, planning permission, or whatever route is taken, and grid connection, given that they are mutually interdependent and highly relevant to each other. And thirdly, a clear recommendation that the national policy statements should give significant weight to the availability of a grid connection, make sense of these two parallel processes by saying, well, if you've got a grid connection, you should give that significant weight in the decision-making process. But I think it's fair to say that we haven't got there in the energy suite. And the reason I say that is because what EN1 and EN3 really say is that the grid connection process is outside of planning. It is a process which is not governed by these policies and is not something which should be the subject of interference or really even scrutiny in consideration of applications for development consent orders. EN1 notes that applicants might wish to take a commercial risk. In other words, projects may come forward where there isn't a grid connection. That's seen as a matter of commercial risk and effectively, therefore, not a matter which should be driving decision making. In EN3, there's recognition on each of the technology types. So this is offshore wind, solar, and onshore wind in the quotes provided, that effectively the presence of grid export capacity and the identified location in the case of offshore wind, the identified location or the presence of the capacity is something which may inform the choice of where the infrastructure is located. So there's recognition in policy that, in essence, the search criteria, the spatial elements of the project have already been determined once you have identified available grid export capacity. Now, bring that forward into gate 2 to whole queue, and a path having been identified by NESO for meeting Clean Power 2030 or for achieving the wider objectives of decarbonisation. Bring that in to the inevitability that projects are going to be looking to meet milestones within the grid connections process, as well as the task of securing development consent or planning permission. And you start to see that the grid process is taking place separately from planning, but is highly determinative as to the planning outcomes, at least under the national policy statements. EN5 is perhaps the most robust example of this, which recognises that where you're looking at electricity transmission infrastructure, the Secretary of State should bear in mind that the start and end points are not within the control of the applicant. Effectively, those have already been determined and will be determined by the presence of new or proposed generating stations or system capacity and resilience requirements. And it's then explained at 2.2.3 that effectively the reality is that with those matters already having been worked out, there is going to be a very significant amount of new electricity network infrastructure, and that may be appearing in places where it hasn't been seen before. And that sets the tone for EN5, critical national priority, outweighing of all but the most serious harm. There's then the question of what does the decision maker do about the strategic spatial energy plan? There's recognition in EN1 and EN3 of the existence of those documents. EN1, these should be considered by applicants together with other relevant considerations and used to inform developments. Well, of course they must be, because alignment with the strategic spatial energy planning process will be a necessary step towards getting a grid connection if a grid connection hasn't already been secured. So the suggestion that an applicant for a project should consider strategic spatial energy plan is, of course, a point that is perhaps stating the obvious. And I think perhaps the most critical piece of advice is here in EN3 2.3.9, noting that most renewable energy resources can only be developed where the resource exists and where economically feasible. And because there are no limits on the need, there is not a consecutive approach in the consideration of renewable energy projects. In other words, there is no sequential testing of the location of renewable energy projects. Secretary of State should also consider spatial plans, such as the Strategic Spatial Energy Plan, once it's endorsed. So it's there, but effectively it's only there as background because national policy statements are, in essence and by choice, location neutral for renewable energy generation. But then what about local plans? And what about the emerging spatial development strategies at the combined authority level? In those plans, there may or may not be reference to strategic spatial energy planning. There may or may not be consideration of them. As plans come through the system, there may or may not be a genuine and consistent effort to make sure that local plan making and spatial development planning, the strategic level, is going to incorporate the considerations from energy planning. And for me, that is potentially a significant gap. And at present, it is unclear how that will be filled. No doubt NESO will want to be involved in plan making processes. But given there are dozens and potentially hundreds of those processes ongoing at any time in due course, then it's quite hard to see how NESO would be able to be across all of those plan making processes. So then the final point is sort of grid connections on the ground. What does this mean in practice? So I think it's useful to look at some of the development consent order decisions, and in particular in respect of solar, where locational choices are driven to a large extent by the availability of a grid connection and the availability of land, and the absence of the highest level constraints. What you see in the decision making, and there's some good examples, Mallard Pass and Helios provide two good examples, is an acceptance that the grid connection location is the driving factor when you're looking at other site search factors. So in Helios, for instance, a very substantial amount of best and most versatile agricultural land, but the Secretary of State ultimately accepted that you had to be within 5 kilometres of the point of connection, and that meant driving the development towards best and most versatile. A recent decision in Lincolnshire, then also at in a Town and Country Planning Act appeal, where the Inspector Major, accepted that a primary driver of site selection for solar farms is the availability of a grid connection, which offers a quick and confirmed opportunity for linking the solar farm to the grid, vision of renewable energy, and the opportunity to connect to the grid at an early stage are benefits of substantial weight. And there again, the point was made that if you're going to be within 5 kilometres of the grid connection, you are going to be developing best and most versatile agricultural land, and that is a justification for doing so, accepted by the inspector in that case. So finally, before I hand over to Odette, who's going to look at emerging policy in more detail, I just raised the question as to whether the NPPF consultation is an opportunity for those in the system to ask for a bit more coherence between energy planning and town and country planning, so to speak. The draft policy W1 in the NPPF does mention consideration of relevant infrastructure plans, which would include the Strategic Spatial Energy Plan and the RESP. But at the moment, it doesn't provide express guidance on how to approach the existence of grid connections. So with that, I will hand over to Odette.
Thank you, Richard. So yes, I'm going to follow on from Richard and take a broader look at some of the recent big changes in Town and Country Planning Act policy that have taken place since our last webinar. And some of this relates to grid specifically, but some of this is also in terms of broader reform that is ongoing in the planning system at the moment. And there's 3 points I'm going to touch on. So first, the NPPF consultation, which Richard just touched on, then the new national policy statements that have come into force, and finally, a change in some more technical specialist guidance that relates to the planning practice guidance for renewable energy. So the first point then is the National Planning Policy Framework consultation. And so the consultation closes on the 10th of March. So as Richard said, there's time for people still to send in consultation responses. I think the general emphasis of these NPPF updates tends to be targeted at housing, but I think some of the solar and battery storage and grid implications sometimes go a bit under the radar and are not always entirely anticipated. And a good example of this is the change in grey belt policy in the last iteration of the NPPF, which in many respects was targeted at promoting housing development. But having researched this recently, proportionately far more solar farms have been accepted as grey belt schemes than housing. And that's because they don't need to pass all kinds of tricky tests on need, sustainability, golden rules, and so on. So there is scope for some quite drastic reform in terms of planning policy with this document as well. And there's 3 policies I want to look at. So the first is W2, which relates to plan making. Second, W3 relates to decision making for energy specifically. And the third is S5, which is the new draft policy on decision making outside of settlement boundaries in general. So the first then, W2, which is the plan making policy about securing renewable and low carbon energy and electricity network infrastructure. And this very much follows on from what Richard was talking about in terms of the interaction of the planning system and energy planning. The first point is that under this new draft NPPF, there's an explicit bringing into the system of network infrastructure. So the current draft NPPF is very much focused when it talks about energy on renewable and low carbon energy, less of an explicit focus on matters like grid, substations, transmission and distribution networks. And that is now all included in the definition for all the policies that refer to energy. And that applies to W3, which is a decision-making policy as well. The second point here is Richard went to the current NPPF policy on local plans and what they should do in terms of allocating land for energy, which is currently paragraph 165. And as we saw, that says that essentially local plans should consider identifying areas for low carbon and renewable energy. That's not happened in the vast majority of cases. Plans just don't do that. But what we have now proposed is a much stronger requirement in policy W2. So not should consider identifying, but the plan should identify areas suitable for renewable and low carbon energy and electricity network infrastructure. So that's very interesting. And again, quite unclear how that process is going to work alongside the Strategic Spatial Energy Plan, because local plans are in the new system themselves have to identify areas that are suitable for this type of development. And agree entirely with what Richard says, that we need a bit more clarity as to how that process is meant to work and to interact with the broader spatial planning that's ongoing. So one question is where in the new hierarchy of local plans this identification is going to go. And policy PM1 of the new draft NPPF, which relates to spatial development strategies, identifies that so the spatial development strategy level, that sort of higher tier, these are the places where provision for infrastructure that is committed to in any sectoral spatial plans, so assumably that would include the SSEP, should go. So they're going to be in spatial development strategies, these identified areas, and they have to identify provision for infrastructure committed to in the sectoral spatial plans. And again, what that means is very, very unclear at the moment. But of course, if this policy comes into place, will be worked out, have to be very quickly. So that's in terms of local plan making. Second policy then is decision taking, and this is policy W31. And this is the key energy decision making policy. The first point here then is that what we've got in the current NPPF draft at paragraph 168 is a requirement to give significant weight to renewable and low carbon energy development. And that was introduced in the December 2024 NPPF. The clear intention was to be helpful, to encourage these schemes to get consent. And that was made very clear in the consultation response for the last NPPF. But it hasn't quite worked out that way, because at a number of inquiries I've seen in the last year, you have local authorities and objectors saying, aha, it says significant weight to clean energy, so we don't have to give it substantial weight, despite a whole raft of previous decisions saying you should give substantial weight to clean energy. So while the intention was to be supportive, it sort of backfired in some sense. Notwithstanding people making those arguments, a lot of decision makers are still saying, okay, it says significant weight, but that could be significant weight to a 1 megawatt scheme. So if you've got a scheme that's 40 megawatts plus, it's still substantial weight, and that significant is not a cap. And I've put some examples on the screen. But in any event, the new draft text would deal with that, because it's now proposing to identify that there should be substantial weight to energy projects. And this is not just to energy per se, but it identifies that substantial weight to be given to energy security, economic development, and moving to a net zero future. So identifying these as sort of separate benefits of these types of schemes. And that's consistent with a big theme in Clean Power 2030, which is really, at least presentationally, really trying to emphasize the point that clean power is not just about the climate crisis, but much more importantly, the current government, about economic growth and about energy security in a sort of international political turmoil world. So quite helpful, I think, in terms of decision making, this new approach that's proposed. So that's part one of W3. The second part of W3 explains that where proposals for this form of development come forward outside areas identified in the plan, they should be assessed against the NPPF as a whole. So this is quite interesting. What happens if the local plan, the spatial development strategy, comes forward under W2, identifies areas for renewable energy, seeking to fulfill the SSEP, as we saw, and you're not in that? Then what happens to your development? Does that pose a problem? Is this going to be a barrier to you coming forward? Is it going to constrain delivery outside areas that aren't identified? And what W3 tells us is you've got to look at the framework as a whole to make decisions in those circumstances. And we just saw part one of policy W3 says you get substantial weight, and you get that substantial weight whether or not you're allocated in a plan. So it's a pretty promising starting point, even if you haven't been identified in one of these new plans. But even beyond that promising starting point, the other really key policy in the new draft NPPF to go in terms of the in principle locational acceptance of these schemes, energy schemes, is policy S5. And this is the principle of development outside of settlements. And what this policy is intending to do is to say that where you're outside a settlement, so as you will be for all energy schemes generally, such schemes should be approved unless the benefits of doing so would be substantially outweighed by any adverse effects if you fall into a number of categories. And one of those is engineering, operations and infrastructure, including for energy. So my reading of this is that if you're proposing an energy infrastructure scheme, which seems to me it could cover the whole gamut of solar grid, batteries, cable, substations, if you're proposing that kind of scheme, under the new policy S5, that should be approved unless the benefits would be substantially outweighed by any adverse effects. That's a pretty high threshold, considering, as we've just seen, you've already got a starting point of substantial positive weight under policy W3. It doesn't apply, I've noted there, to Greenbelt, but I did mention at the start on Greenbelt, Greybelt has seemed to me to prove a massive revolution in energy schemes. And two examples of how that's worked I've just popped up on the slide, the Filongley and Burcott appeals from last year. So the overall takeaway, as I see this, if these policies are applied properly, and if you get substantial weight in all cases, and you're only refused if the benefits are substantially outweighed by the harms, it doesn't seem to me that it would matter hugely if the policies are applied properly, whether you're in a plan or not, notwithstanding the new requirement to allocate sites, because the planning balance looks pretty punchy, whether you've made it into the plan or not. So that's the overall takeaway. I mean, hard to know whether or not that's how it will work in practice. We see with housing development, local authorities taking very different stances depending on whether something is allocated or not. But it does seem to me a very positive policy framework that the government is intending to bring forward in the next few months. And the anticipated publication of the NPPF is a pretty quick, I think, turnaround after the consultation closes in March. So we could have this before the summer as the new framework. So going on then to touch about the other big planning policy change that's happened since the last webinar, and again, something Richard touched on earlier, and that's the designation of the new national policy statements. They were out in draft last year. The date on them is December 2025, but they were formally designated only in January of this year. And the transitional arrangements are as usual. So these apply to DCO applications yet to be made or not yet accepted for examination. And those that have been accepted for examination beforehand, the old 2024 NPSs will still apply, although the new ones can nonetheless, as they can in planning, town and country planning act cases, be a material consideration. And there's a number of things on a number of technical criterion, decision-making policies that have changed in these, and we don't have time to go into that in a lot of detail. But I just want to highlight for this webinar 7 very high-level key points. So the first one, number 1 and 2 here, closely related. So by virtue of the Infrastructure Planning Onshore Wind and Solar Generation Order 2025, which came into force at the end of last year, 31st of December 2025, 2 changes have happened in relation to how schemes are determined. So first, onshore wind, that's now been brought back into the DCO, the Nationally Significant Infrastructure Project system, where it hadn't been previously. All schemes were determined under the Town and Country Planning Act in recent years. But now schemes that are over 100 megawatts can be determined under the DCO regime. So the bringing back of onshore wind, and there is also new guidance in relation to onshore wind in NPS EN1 and EN3. And the second point is related to this, so that the 100 megawatt threshold for onshore wind, that's now in place also for solar. So the solar threshold has increased from 50 megawatts to 100 megawatts for schemes to be considered under the Planning Act 2008 regime rather than the TCPA. And there are transitional arrangements under the 2025 order. So if you've applied under the old regime for planning permission or put in your DCO application, you're not going to be changed regime if that's gone in already. It's essentially the thrust of the transitional arrangements, but do take a look at them more closely if this is something that's relevant to your scheme. So the point 3, in terms of these changes to the NPS that are relevant, is the introduction of the Clean Power 2030 targets. So these are specific numerical gigawatt targets by 2030 that the government set out in Clean Power 2030 they want to achieve. So 45 to 47 gigawatts of solar, for example, up from, I think we're on roughly 18 gigawatts at the moment. There's targets for wind, there's targets for BESS, and those have been incorporated into EN EN1, and I think that just gives them a bit more weight in decision making, including under the Town and Country Planning Act. It's not just guidance, it's national policy, planning policy now. Linked to that, again, a reminder from the government in terms of solar specifically, it's been very clear in the new draft EN3 that solar is at the heart of its Clean Power 2030 mission, and very bold statement that deployment needs to radically increase. And none of that's surprising, but again, just further weight to be given to that need in all kinds of decision making on these projects. So the next big point, and again, this follows up from what I was talking about in terms of the NPPF and from Richard's presentation, is that the critical national priority designation, where, as Richard explains, the presumption is consent, essentially, for low carbon energy projects, that remains, and that's a very powerful presumption. The energy from waste schemes have been excluded from the critical national priority designation, but for all other schemes it remains. And how that relates to the spatial energy planning point is interesting, because as Richard points out, there is now for the first time a requirement in EN1 to consider any strategic spatial energy plan that is formally published and authorised. But like with the NPPF, if you consider the strategic spatial energy plan and the area in which the scheme proposed has not been identified within that, what does that mean? Does that mean the scheme should be refused? I mean, my view is if critical national priority is still in there, it can't do that because the policy presumption in favour of these schemes is so strong. So again, it's going to take some time to work out what that requirement to consider the SSEP really means at the hard edge of a decision whether to grant a scheme that's not included within it. And then the final point I just wanted to make on the new draft NPSs is a reference to the centralised strategic network plan for grid. And those are included within the new EN1 and within the new EN5. So again, trying to link energy planning with planning policy in some way. And I think the clearest change here is that the EN1 is now clear that the need for network infrastructure in any given case will be established by the centralised strategic network plan. So if a project is included within that suffices to establish the need under the national policy statements. Lots of other things we could dig into in the new NPSs, but these were just a few points that I thought are of broader interest in relation to this webinar. So then finally, before we move to the Q&A, something a little bit more niche, but of a lot of interest to many people who are involved in battery proposals at the moment. We will all remember several years ago the advent of the NFCC, National Fire Chiefs Council on Battery Storage Planning, and a couple of summers ago the introduction of reference to that in the planning practice guidance for renewable energy schemes. And what the planning practice guidance says is that this specific guidance is something that has to be considered by local authorities and applicants when battery energy storage proposals are put forward. And it's had a decisive role in a number of appeal decisions where battery proposals do not meet the NFCC requirements because of matters such as spacing or fire water supply. So it's had a pretty powerful influence on the planning system. And there was a promise to update it. There was a consultation, and we've had several years of waiting for the new NFCC guidance. And last week, this has finally been published. And it makes quite a number of important changes in terms of design of battery energy storage systems. So I think critically, it's no longer suggesting that you need a minimum of 6 metre spacing for all BESS developments. It's also made some changes in terms of water supply, accepting that water supply requirements can vary on a case-by-case basis and can be reduced significantly if application of water is not the manufacturer's recommended technique. It's changed some of the requirements in terms of vegetation clearance, reduced those, and a number of other sort of technical design changes that overall are going to be encouraging and facilitative of BESS schemes coming forward, notwithstanding the massive grid constraints on BESS that Natasha touched at the start. But in terms of planning and design, this is certainly a facilitative step. So those were the key points I wanted to touch on, and I'll hand back to Richard now for the Q&A.
Thank you very much, Odette. Thank you, everyone. So we'll pick up some of the questions that have been posed to us. Can we start, Natasha, with the interesting point about requests for indemnities, and sort of obviously that's going to be problematic for some people who are yet to know the detail of what their offer is, and in particular the timing of it. What's your suggested approach to that request?
Thanks very much, Richard. Yeah, we've had a really interesting point raised by Daniel Mewton. Just to put a bit more flesh on what the question is. He's noted that a number of people, a number of clients have started receiving requests from NESO for indemnification costs incurred in progressing the works on an interim basis, pending the Gate 2 modification application being issued, with the indemnity being triggered if the customer does not ultimately accept that modification application. And the questioner quite understandably raises some of the points that I was covering earlier about the security freeze and about the lack of trust in the grid at the moment, and a lack of trust generally as to whether connection offers are going to mean what they say on the tin. So I think that's a really good question to ask. I think there are a number of points to unpick here, and I'll obviously only be talking at a really high level. So firstly, it sounds like the offers being made are just that, they're offers to sign an indemnity for the purposes of progressing the works. As far as I'm aware, there's not a a requirement in any kind of guidance that such indemnification offers need to be agreed to. So it seems like it's kind of a catch-22 where projects are being asked to sign up to something in the expectation that if they don't sign up to it, then their existing connections offer is not going to be progressed. It's quite a tricky situation because obviously time is key. But I think probably at a very high level, my suggestion would be that either declining to accept the indemnity offer or starting with a strongly worded letter saying what's going to happen if we don't accept this indemnity offer might be a first point of call. And then if and when any tools are downed as a result of that indemnity offer not being agreed, then making use of the ADR mechanisms, raising a complaint through NESO on the basis of non-compliance with the existing contractual agreement. That would be a very high level kind of thought on where to start, but obviously, as with all of these things, we do really need to clarify that so much depends on the facts of the case, obviously, and yeah, each situation would have to be assessed on its own terms.
Thank you very much, Natasha. There was also a question which is probably worth just quickly picking up, which is that if a project is protected, has it necessarily reached those first three milestones, so through to planning consent having been obtained, etc., land rights, planning application, planning consent, I think it is. Is that always the case?
Oh yeah, that's a really good question as well. So I think the simple answer is it's probably usually the case, but it's not necessarily the case. So the strategic alignment criteria that I outlined earlier, one of them was that projects are significantly progressed, and a kind of general understanding would be that a lot of those milestones would therefore have been met if a project is in that category. But the first clause is that projects contracted to connect by the end of 2026 come within the protected criteria as well. So, we can't exclude the possibility that there may be a project that does have a quite soon connection date that actually hasn't progressed very often. So it's a question that turns on the facts of the case. But I think I don't know what the percentages are, but I'd say it's probably quite likely that a fair number of the protected projects, potentially, if not all of them, are quite far advanced along the milestones.
Thank you very much. So I'm going to pick up a couple of the points about SSEP and so on, and ask Odette to come in on them as well. So first of all, thank you for the clarification from one member of the audience who's identified that the SSEP has slipped through to 27. So I think we get a first draft either at the end of this year or beginning of next, and then final publication expected in 2027. I suppose that sort of, again, makes us think about planning in the interim and the role of the actual grid connections, because as things stand today, it's the existence of the grid connections that provide the best map as to how we expect to get to the Clean Power 2030 objectives, as opposed to any written plan. For me, that strengthens the argument that if you're looking at a particular project, the existence of an early connection date is sort of confirmation, not just that that project meets the wider policy of delivering as much renewable energy generation as possible, but also that it actually is on the path. It's on the path that's needed. I don't know if you've thought about that in terms of that interim period between now and when we have better sense of the strategic planning side.
I mean, agreeing entirely with what you've said. I have noticed in recent appeal decisions that for the first time, I think in the last 6 months or so, inspectors are consistently giving significant weight as a separate matter to the renewable energy generation per se, to schemes that have got secured grid connections under Town and Country Planning Act in particular. So they are alive to this, and they're leaning into it where people can evidence that they've got that type of connection.
Yeah, and I think the other point that's raised in a question is about sort of the relationship between the SSEP and its sort of broad zonal consideration, and how that sort of turns into parcels of land on the ground. So that flow down from the strategic plan into sort of planning decision making. I don't know, Odette, whether you've had any thoughts about that. Sort of how is that gap being filled between saying this is a broad area where a zone where there's going to be a lot of new solar required, or whatever it might be, through to individual decision making.
Yeah, so I agree entirely that my understanding is the spatial plan is to be broad and zonal in that way. My reading of the NPPF is that the development plan, the words it says, should identify areas suitable for renewable energy. So my understanding is that that's going more to a sort of locational specific, narrower level selection of areas, not just the broad identification in the spatial plan. And when the spatial development strategy the planning plan has to do that, it has to do so in a way that makes provision for infrastructure committed to in the broader zone. So my understanding is that these new style plans will have to go a bit further than just identifying broad zones in the way that the spatial plan will do.
Yeah, I think that's right.
Yeah.
I mean, what I think the interesting thing we're going to see is because of the timing, is we are of course going to see a lot of local plan work and some strategic planning, combined authority planning coming through before we get to a clearly established SSEP or RESP framework for energy planning. I suppose for me, the interesting thing is sort of what's happening in those plans. As we know, those plans, yes, they'll be reviewed every 5 years, but often they stay around for a long time. And if those plans are neutral on locations of electricity generation, or perhaps even anti-electricity generation, that's going to cause some issues, isn't it, in terms of how then we use the strategic energy planning for deciding where these things should go. I think, there is a prospect that there will be local authorities in some areas of the country that will be promoting plans that seek to restrict renewable energy development quite significantly. And obviously that is going to potentially conflict with the assessments that are going on by NESO. From my perspective, there isn't an easy resolution of that, apart from everyone trying to talk to each other. Perhaps the government giving a bit more of a steer about the hierarchy. But I don't know if you've had any other thoughts on that.
Well, no, I mean, just I think that the interesting point of even if your local plan does try to be very restrictive and identify very small areas that are appropriate for renewable energy. The point I was making earlier of does it actually make any difference whatsoever to the final decision making, given the presumption of substantial weight and you should get consent unless substantial adverse harm. I mean, it could mean a lot more appeals and these decisions being determined by central government rather than at a local authority level. But if the new NPPF policies are applied properly, and if the critical national priority designation is applied properly, for schemes of that order, I still see that it would be a hard task to refuse a scheme on the basis that it's not included as an allocated area in the plan, as a matter of in principle unacceptability per se.
Yeah, thank you. We've had some more questions in about strategic planning, both in England and in Wales and Scotland. I mean, I'll pick up the Welsh example first. I think, as I mentioned in my slides, obviously Wales is sort of slightly ahead of this process by identifying suitable areas for some types of energy infrastructure, and also identifying expressly in national policies areas where new large-scale energy infrastructure will be inappropriate. So there isn't a policy in England that says you can't do this in AONBs and national parks. There isn't a full stop prohibition, whereas in Wales, that's what Future Wales tries to do. And obviously, in terms of where you should put it, the idea is that for wind infrastructure, large scale wind, you should be in the pre-assessed areas. Well, at least if you're in the pre-assessed areas, you should be acceptable in terms of at least landscape impact, potentially not other impacts, but at least landscape impacts that should be acceptable. So there is already that sort of spatial element through the decisions that have been made. And of course, in Wales, saying nothing in a national park and nothing in an AONB means that there are broad areas that are excluded from large-scale renewable energy development. In Scotland, I mean, there are similar policies in NPPF 4, which of course is also designed to be highly permissive, like the English policy is highly permissive of renewable energy. And certainly in response to the question about existence of grid connection, I've certainly seen a number of decisions where grid connection has been seen to be an influential and important factor that justifies some of the harm that's being said to be outweighed in the particular location. I don't know if anyone else wanted to come in on that.
Well, I mean, it is quite a different system in Scotland, and I'm not sure we could do justice to it in the last couple of minutes we've got now. But if there is interest in more discussion of recent reforms in Scotland, please do feel free to email in your feedback to this webinar. And if people want it, it's something we could definitely consider for future events as well.
Yeah. And just picking up. We've only got a couple of minutes left, but let's just pick up a couple of points. I mean, there's one question which is about solar and location of solar. I suppose the short point is that a choice has been made in national policy, at least for DC NSIP scale solar over 50 megawatts and over. The delivery on agricultural land is both necessary and acceptable in principle, that the use of best and most versatile agricultural land is just one factor to weigh in the planning balance. But where you're dealing with critical national priority, I think the clear thrust of the policy now is and certainly its application is that you will be outweighing those harms with solar. There's that. You'll see in my slides the reference to it effectively there is no policy of saying where you should put this. In other words, there's no sequential testing that you should go to previously developed land first or rooftops first for solar. I know, Odette, you've had similar arguments in a number of appeals.
Yes, I mean, I think the position's a bit more confused under the Town and Country Planning Act, but we haven't had many decisions that have, there's been one or two in the last 4 or 5 years that have been refused on the basis of best and most versatile agricultural land. I think I mean, all we can say really is that it is government policy that we need maximum deployment of ground mounted, which will mean greenfield, and rooftop solar to achieve the 2030 targets at least. And while that is the current planning policy, it was confirmed again in the solar roadmap last year as well. That's the policy decision makers have to apply for the time being.
Thank you. So I think we're just about to have time, so I'm going to wrap it up. Couple of points just to flag at the end. First of all, one of the questions makes a very important point, which is, well, what about the supply side? What about the demand side? We're talking about supply here, generally generation. The answer to that is yes, that's important, and I think we will have to take that away and try and see if we can cover it at another webinar in due course, because certainly, and I'm sure others on the call are in the same position. Certainly, I'm seeing a lot of interest about timing of connections for things like data centers, and we've got recent Ofgem decision making recognizing that side of the equation is just surging in terms of interest, in terms of connection requests, and particularly at the transmission level, and that's going to be a major issue in due course. And finally, just before I wrap up, I'm sorry that obviously some of you haven't been able to properly use the Q&A. I'm sorry that's happened. We'll check out what's happened with the system there. But hopefully at least some of you have been able to follow the questions, and we've tried to summarize them as we go along as well. So with that, I'm going to wrap things up. Thank you very much for attending. Thank you, Odette and Natasha, for your talks. And we hope to see you again soon at one of these events. Thank you very much.